Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Tuesday, May 8th, 2018. Time is approximately 9 o'clock a.m. and we are meeting in the hearing board room in Diamond Bar. We have one matter on calendar for this morning, and that is Beverly Hills Unified School District, case number 6107-1 for an emergency variance. And who is here representing Beverly Hills Unified School District this morning? And when you speak, you don't have to rise. Just make sure you turn the microphone on and speak into the microphone for the record.
I am LaTanya Kirk Carter, the Assistant Superintendent of Business Services for the Beverly Hills Unified School District.
Thank you. And can you spell your last name for the record?
Sure. KIRK-CARTER.
Thank you, Ms. Kirk Carter. And who is representing the district this morning, the executive officer?
Good morning, board members. Nicholas Sanchez and Daphne Sue on behalf of the executive officer.
Okay, let's begin with the school district. Ms. Kirk Carter, do you have an opening for this morning?
I will defer to my consultant.
Okay. And can you please state your name, spell it, and just state who you are for the record?
My name is Mary Jane Wilson, W-I-L-S-O-N, and I am president of WZI Inc., an environmental and engineering consulting firm.
And Ms. Wilson, I assume that any statements you make you'd like to count as evidence in today's hearing?
That is correct.
Okay, then I'm going to ask you and anyone else who is planning to testify today to please stand to be sworn in.
You can be sworn in.
Please raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Chair Prusak, before we begin, following the petition by Beverly Hills Unified School District, the facility has modified their permit, and the district did issue that new permit just this morning. And so based upon that occurrence, the facility is now in compliance, and I recommend that they withdraw their petition. Staff worked on it this weekend to try to remedy the situation. We appreciate the board issuing coverage through this hearing. We were able to find a solution, and so with that solution, there's no need to proceed this morning.
Well, thank you, Mr. Sanchez, and I appreciate the diligence of the district, and we're working hard over the weekend to come to compliance. Either Ms. Wilson, Ms. Kirk Carter, would you like to withdraw your petition, or would you still like coverage today? It sounds like you don't need it.
We would like to withdraw the petition.
Okay. And I assume I assume that any excess emissions that may have occurred over the weekend under the ex parte emergency variance, that will be taken care of under the ex parte petition, the ex parte variance?
We did calculate the excess emissions that have occurred, and we did request in the ex parte petition to have the fees waived because of the fact that the school district is the owner through no fault of their own of the facility.
Okay, so are you, and I have to see if that's actually proper now that the ex parte has already been issued. As the issuer of the ex parte, I do not recall a request as part of that petition to waive the fees.
It was the last page on the petition.
Okay. I don't have the petition before me. I'm going to, we're going to take 5 minutes off the record, because if you're wishing that waiver will need to come from the board as part of a motion. And I need to make sure that at this late date that can still be determined. So we're going to go off the record for at least 5 minutes so that I can look into that and also make sure I have a copy of the petition.
Thank you.
Okay, and we're off the record. We're back on the record. It seems as though the request was made in an attachment to the petition, which was not received, unfortunately, by email. However, looking at Rule 303M, which regards our this board's discretionary powers with regard to fees and either waiving fees in whole or in part, doesn't seem to have a time restriction on when that can be considered. I'll just read it into the record so that we know the standard by which we have to make this decision. So it states, any person may allege that payment of any of the fees within this rule, excluding publication fees, will cause an unreasonable hardship or is otherwise inequitable, and that you may be excused in whole or in part. So given that, we'll allow the motion, and if you could just take a few minutes to briefly state for the record the basis for your request, and then I'll go to Mr. Sanchez and ask if he has any objections or any statement he wishes to make.
Mary Jane Wilson to the board. I just wanted to explain to you that we are spending right now well over $20,000 a day to increase the safety on the site, and that preserving the money for that purpose is extremely important to both the district and the city of Beverly Hills. So we are just starting on the program to plug the wells, and everything is a little more expensive and taking a little bit longer than anticipated for the project, and so we really need to preserve the money for getting rid of those wells.
Thank you. Mr. Sanchez, first your position, and second if you have any questions.
I don't have any questions. The district doesn't have a position, as we've consistently responded to these requests from petitioners. However, the district can confirm, it's our understanding that this is an ongoing project. They have been in ongoing communication.
If we could just pause, I'm sorry. For some reason, this seems to happen often. We'll just wait for it to end. We don't know where it comes from. Our apologies, Mr. Sanchez. You may continue.
Now I'm excited for Stranger Things Season 3. And so it's the district is aware and has been in communication with the facility as well as Dogger, as I included as an attachment. So this is an ongoing process at a significant expense to the school district. And just a brief background, the previous owner of the facility, pursuant to an order by Beverly Hills, the city of Beverly Hills, all oil production was to cease in the city beginning in December 2016. The previous owner did not adequately prepare to meet that deadline and ultimately abandoned the site and claimed bankruptcy, which caused the school district to inherit the site and all the obligations to close the facility. And they have been doing so and finding things and performing triage, so to speak, to remedy the situation. And I can confirm that those costs, as represented by petitioner, are ongoing, and for that reason, there is a basis to grant relief in this case. Thank you.
Thank you, Mr. Sanchez. First, I'm going to ask, since that was kind of evidence, and I was going to ask Ms. Wilson that question. Ms. Wilson, can you confirm that the information that Mr. Sanchez just provided in terms of the background on how the school district came to be in possession of these wells is correct?
Yes, I can, and if you have another small break, I can bring my written testimony that I was prepared to give for the granting of the variance if the permit was not yet there, and I have the judge's order from bankruptcy, which gave the site to the school over the protest of the school. We went to Delaware to try and have the operator give one of two things, either the money to properly close the site or to close the site themselves, because they were required to restore the site to its original condition. And the bankruptcy judge chose not to do that. And within a month of his ruling, the school was the proud owner of the site.
Unless other board members would want to see that, I think that your testimony is sufficient evidence for the current motion, but I'll allow other board members to ask questions if they wish. But before we do that, Mr. Sanchez, you mentioned the letter from Dogger, and that was attached to the district's response to the ex parte, and I do not believe other board members have received it, and it has not been marked as evidence. Do you believe that that is relevant or important to the current motion with regard to fees?
I believe so, because it's an advisory letter from Dogger that gave a deadline and identifies the need to expedite closure of the site and reduction of pressure in the wells.
Do you happen to have copies with you?
I can file copies with the clerk after.
I'm sure the other board members, since they'll be voting on the motion, would probably like to see the,
Yeah, if we can take a quick break and I can make copies.
okay. Before we do that, I'm just going to ask board members if you have any questions for Ms. Wilson, and then we'll take a break before we deliberate. Mr. Camarena and then Senator.
I have a question for the chair. I have no documentation that the ex parte was granted. Was it granted?
We're going to take a break. Unfortunately, we heard through the grapevine that the request for the emergency variance was going to be withdrawn, and so no copies were made either of the petition, or they were made, but they were not circulated, or of the minute order. So we have to make copies, is the answer. So we'll do that.
And the answer is yes?
The answer is there is a minute order. Is that the question? It was granted.
Thank you.
Yes. It was granted, and we will take a moment to make copies. Senator, did you have questions, or maybe we should take a moment to make the copies and then come back?
Take a moment. I got a number of questions to ask you, so we'll do it when you come back.
Would you prefer to wait, or would you like to
Well,
ask those
ask them right
questions?
now, then.
Sure.
These wells, how many of the wells? 14, I think?
There are 18 active wells and one well that has a plug in it. So there are 19 wells total that have to be re-entered during this restoration project.
And how long were the wells operating at that site?
They were there since the early 80s, like 1982 to 84 was when they were drilled.
And the money derived from drilling those wells, did the school district benefit at all?
Yes, the school district received royalty payments.
You have an idea in the order thereof?
I have never calculated the volume of royalties, and I don't believe that anyone here knows the exact number. I didn't ever try and calculate that.
So to the assistant superintendent, you receive average daily attendance, correct?
We don't. We are actually a basic aid school district, so all of our revenues come directly from property taxes.
None from the state?
No. I mean, we get
Come on,
minimum state aid, but
You get state
But
aid.
it's similar to ADA, but we surpassed the ADA calculation, so we're a basic aid district.
You receive state money, yes or no?
Yes, we do.
Okay, that's the point, whether, however you want to classify it, you still receive state money.
Yes.
And you receive money from oil wells as well initially.
We did receive oil royalties.
Rich school district compared to some of the other districts. And you did receive ADA. So you get, everything's been in your favor for a number of years.
Yes, we received good money from property taxes, which would be ADA, and we did receive royalty payments. when the oil well was functioning. The contract with us and the leasee, though, did not, it wasn't our responsibility to cap the well. It was in the contract between us and the owner, and they knew many years before the ordinance took place. We started meeting with them as early as 2014, that we would not be renewing the lease, and that the lease would be coming to an end, and that they would have to restore the land in December of 2016.
And in 2016, they disappeared, is that correct?
Yes, sir.
Okay, between
May I just interrupt for the record? I was taking notes and I didn't realize Ms. Kirk-Carter was speaking. When you speak, can you just identify, because we keep a record, an audio copy of each proceeding?
Yes, ma'am.
between 2014 and 2016, did the school district receive any royalties?
Yes, we did.
Even though, so it's still operating?
I'm sorry?
The wells are still operating?
They were still operating.
But you knew they were closed down in 2016?
Yes.
Now, the plan is to cap all of the wells?
Yes.
And then what's the timeline for that?
I'll let Mrs. Wilson answer that question.
Through the chair, my name is Mary Jane Wilson. The approximate number of days that it will take to plug the wells is about 270 days. The wells were left in such a condition from the time that the operator left they shut in the site. That means they just turned the wells off. They didn't do anything to preserve them or to take care of the fact that they knew that they weren't going to be restarted. So the site was left to the school district 6 months after they shut in the wells. By that time, there had been an extensive deterioration of the surface facilities, as well as we did not know what the downhole condition of each of the 18 active wells were. So basically the keys were tossed over the fence and the school district had to pick it up, and the site is on 3/4 of an acre on the school property.
Now, what about these flares that you're saying you needed?
The flare is to destroy the natural gas as we plug the wells, and the time period between, it'll cost probably $8 million to plug the wells alone, and that doesn't include the site restoration. So it was a considerable amount of money that would have put the school district into great distress to have to provide that money for the plugging of the wells. And so what we ended up doing is the city of Beverly Hills agreed to fund the plugging to make the site safe, but the time period between realizing how much it would cost and what the conditions of the wells were in the site, the pressures had continued to increase. They were already high when the school district got the wells, but it was continuing to increase, which is a very unusual situation in an oil and gas field. And so we ended up calling Wildwell Incorporated because of the high pressures and the deteriorating condition, and they made a recommendation to depressurize the wells as soon as possible, as well as to take down the derrick that was on the site covering up a portion of the wells.
When I read the petition, somewhere in the petition, that I'm understanding that the flares are being ordered, or that's part of the operation of shutting the well down.
I'm sorry, I didn't understand.
With flares being ordered, purchased, is that part of the flaring as part of burning it off, or?
Yes.
Okay.
We applied for a permit to utilize a flare rather than venting through the vent stack, and the carbon canister system that we had put on to protect from odors and other things of venting. When the facility was originally given to the school district, there were unpermitted carbon canisters on the site and other unpermitted activities that had been taking place. So we reported those immediately to South Coast and revised some of the permits so that we could do maintenance activities on the valves and on the surface facilities to keep the wells in control.
I understand you're gonna carefully shut these wells down.
We're carefully working on these wells at this time
To
to get the
deactivate them.
pressures down, yes. We haven't started the plugging yet because the Wild Well Incorporated, who are the well control specialists, thought that we should remove the standard derrick, which is sticking way up there. If you look at a Google photo, you can see
PVC,
the
saw it.
derrick.
Yeah, I know.
That is not an operational piece of equipment. It's just been there since 1984 or 82, and it covers up half the wells that are under the cellar. So if we had an uncontrolled situation, we would have to deal with that steel structure to get at the wells, and that was too much of a safety hazard.
Final question. You carefully closing these wells, it's understood. With an expert on the site assisting you in that effort, do you plan to open the wells again and reactivate them?
No. There is a city ordinance not to produce any oil from the city of Beverly Hills. And in addition, I think because of everything that's been learned from having the school district take over the site, there would be a sizable amount of difference in how the permits for that kind of activity in the city of Beverly Hills would be let.
They need majority vote, probably won't happen. Thank you.
I had questions, but I see Ms. Burden. Okay. Can you tell us, I see attached to the petition is a check for $1,218.06. Are those the emission fees?
No, that was the application fee
Okay.
that was given to me by the clerk of the board.
What are the emission fees? Do you know?
I believe they would be approximately $45,000.
And do you base that on what?
We calculated the excess emissions to last night.
What are the excess emissions that you anticipate, or that, and this is due to the fact that since Friday, when the ex parte was granted, the venting had occurred over the weekend, is that?
We did.
Okay.
We proceeded with the depressurizing of the wells.
And what were the excess emissions?
We vented approximately 746 MCF a day of natural gas. And with that natural gas, there were 23,000 approximately. I mean, I had it in my papers that I didn't bring, but approximately 23,000 pounds of VOCs.
Any of the VOCs listed as toxic air contaminants?
There is naturally occurring benzene, toluene, and xylene, the BTEX components, and that is about 0.03% by weight. Is that correct, Jesse? Yes. Yes, by weight.
And for the record, how close are you to the nearest resident?
They're across the street from the facility and about, I think, 100 feet, but we did a health risk assessment of the venting, and in accordance with the screening criteria of South Coast using their program, and it showed that there was no significant health risk from the venting. The vent stack is 172 feet in the air, and the site is also elevated, so there is dispersion that takes place.
Was the venting done on Monday when children were in school?
The venting was done every day.
In equal measure?
Not in equal measure. There are differences based on individual wells that were vented and the pressures and the size of the casing. We have delivered to Mr. Sanchez today a spreadsheet that has all the wells, all the estimated venting emissions, as well as it highlights the ones that were accomplished during the period of the variance.
Can you explain, I know you are no longer seeking a variance moving forward. However, for me, it's important in my calculation as to the current motion, as to the fact that we're looking, I'm going to mark for the record, we received a letter from the State of California Natural Resources Agency, nicknamed DOGGR, which is Division of Oil, Gas, and Geothermal Resources, Southern District, to Ms. Kirk Carter of the school district. And it's dated April 6, 2018. We're going to mark that, I believe it came from the district, so we're going to mark that as Exhibit A for the district. Can you explain, Ms. Wilson, why this is dated April 6th, and I read it as part of the granting of the ex parte, and it explains that the risk or the safety risk, as far as DOGGR saw it, set forth a venting schedule that should have been completed in April. Why that was not done?
Mary Jane Wilson to the chair. At that time, we were contemplating that we would be able to begin as soon as we had finished looking to make sure that the flare, which is a PVC pipe, not the flare, the vent stack is a 172-foot PVC pipe, and we had to, and it had been there since the 80s. So we had to look at that to see if it could even take the emergency well venting pressures and things of that nature. But the thing that stopped at this time compliance with this particular letter was that the contractor to bring the fluids on site and the pumps that were necessary in order to accomplish this were said that they would not go on the site without finishing the contract between the city and the school district, which was currently being negotiated between the prime contractor and the city and the school. It's a three-way contract. It was very complex. And so once again, we weren't able to comply with this letter, although we had thought we were going to be able to, and we had a date scheduled, and in fact I had informed the South Coast that we were going to begin it, and we could not. We were stopped because we didn't have any fluids or any pumps. So, you know, there was nothing we could do but to watch very closely on the wells, and at that time, the flare that we had contracted for was stuck on another job in Oklahoma, so all of a sudden we weren't going to be able to destroy the emissions because the flare wasn't going to be there in time to do the work. And so we complied with the request as soon as possible. We have been in close communication with staff and gone back and forth on whether or not we could have the permit that we have issued today. And so it was one of those things that everyone was working as hard as we could to maintain the safety of the site and to get these pressures down.
Just a brief question, should have a brief answer. Approximately when was the district contacted? This letter's dated April 6th. Approximately when was the district made aware of the circumstances and the issue?
I believe it was in late March, early April. I think we had a meeting with staff here to discuss the flare permit and the urgency of getting that done. And the letter came out shortly after that meeting, a few days afterwards.
And you did not seek a variance at that time. Do you have any explanation as to why that was?
At that time, we thought that the flare would be available, and that would be the highest standard of care for the facility and the emissions that would come off. And there is no variance for not having a permit. And so we were in that particular mode. And then in accordance with the highest standard of care to get the pressure off these wells before we had an uncontrolled well situation, we needed to proceed as quickly as possible when we were able to have the equipment on site, which is what we did.
Can you explain also briefly what the modified permit, is that for flaring or is that for, what is that for? Is that for venting?
That's our normal permit that we had for venting emissions during maintenance periods. And it was to allow emergency venting also, but unfortunately for emergency venting at these pressures, we could not go through the carbon canisters because of the pressure constraint. We would have just blown them up.
So just the question is, now that the permit has been modified, the events that did occur over the weekend, they would be allowable now under the modified permit? The venting that occurred?
Mary Jane Wilson through the chair. Yes, they would be allowed for safety purposes. And so we have created a risk ranking of each well. And that risk ranking changes. It's very fluid as we learn more about the wells. And so we are working every day to keep control of the situation until such time as we can get the derrick removed, the flare in place. We can't have the derrick has the vent stack attached to it. So unfortunately, fortunately, we have to put in the flare once we get the permit, and then we can take down the derrick and the vent stack, but we need to have that safety release on the site before we destroy the derrick.
Okay. Just two questions related to cost. What would the impact of this $45,000 of emission fees be on the budget for the school district?
Currently, right now, if you think about it the way I do, is in terms of the safety of the site. During this depressurization, one of the wells, OS 8, now has fluid to the surface, even though we have vented off the pressure. And it would flow naturally. And so we're going to have to think about what we're going to do to that well. And if we were to move in a rig to pull the downhole equipment out of the rig and circulate heavy mud into it to keep that well in control and from flowing. That would cost about the same amount as the excess emissions. So to me, that is a very important ability to move in and control it well. That's basically what the cost is.
So is your testimony that if the $45,000 is paid for emissions fee, that will not happen? What you just described, the next step in plugging the wells, that won't happen? There is no money to be had in the school budget?
There is no money in the school's budget to take care of the situation. The city of Beverly Hills is giving the money to the school. They're kind of helping them by giving the money in order to do this, to keep the school district solvent, because the $8 million is more than the school could bear.
So the costs of plugging will be reimbursed by the city of Beverly Hills?
I should let LaTanya tell you a little bit more about that, because I haven't been totally involved in that difference between the school, but between the school district and the city. But both LaTanya and Mr. Tao can help you.
Okay, then I'm gonna, this is important to the motion. Ms. Kirk Carter, if you can answer the question as to whether these costs are being reimbursed by the city.
LaTanya Kirk Carter, to the chair. The city, we have a cost-sharing agreement with them. They're putting up the $8 million, and they have requested that we pay them back $4 million if we are successful in getting a general obligation bond. None of these costs that have gone or have been associated with the wells, the city is helping us pay for the plugging and the capping, but we had to pay for the initial monitoring, which was, I want to say, $17,000 a week. We budgeted at the beginning of July 2017, we budgeted $1 million that would have normally gone towards student needs, teachers. If you follow our history, we're in the middle of we did a layoff. We're in the middle of a pretty big financial crisis right now. None of these fees were expected. So, for example, the $45,000, I won't tell you that we don't have it. It's just not budgeted for this purpose at all. The city has graciously decided to pay the plugging and capping. In the bankruptcy, we were awarded $760,000. The insurance for us to just do this part was $821,000. Just the insurance for this operation. We're not in the oil business. We're in the education business. And so it has come as a great burden to us.
I'm sorry, if you can clarify, when you say the insurance is $821,000, that's you paying insurance or insurance paying you?
No, we had to pay the insurance for the current operation, the plugging, the down the hole well, the general liability, pollution, evacuation insurance. I have an excellent team because there's no way we could have done all of that. Like I said, I'm in the education business.
Maybe I can help.
I'm sorry, you have not been introduced as a witness, so if you can state your name, spell it, tell us your title for the record, and then state for the record that you took the oath this morning.
Of course. My name is Terry Tao. I am an attorney for the school district, and I have been actively working on the contracts for the district. I did not take the oath, but if you like, I would take the oath now.
So what you're saying is not actually, would you like us to consider it as evidence, or would you just like to explain to the
It
board?
might be better to take it as evidence just because of the fact that I was actively involved in putting much of this together.
Okay, in that case, I will administer the oath if you're wishing to serve as a witness.
I do.
Thank you, Mr. Tao. You may continue.
Thank you. I am the facilities attorney for the district, so I have been actively working to put this contract together with the city of Beverly Hills. When it became clear that the cost was going to be significant in order to shut the wells down and abandon them, the initial anticipated cost was approximately $8 million without taking into account any contingencies. For example, only $100,000 was budgeted for insurance, but now for the control of well, evacuation, comprehensive general liability umbrellas, and pollution liability policies, we're looking at a price tag of over $800,000, significantly over budget. The arrangement that was made with the city was because of the school district's budgetary problems. So the city volunteered to step up, undertake, and contract for the work, and entered into a reimbursement arrangement with the school district, where the school district, if they passed a general obligation bond, would pay back half of the total expenditures up to a cap amount of $8 million. Any amounts over $8 million would be the school district's responsibility. So a fee of $40,000 would not have been budgeted or anticipated and would ultimately be something that the school district would pay for. The district right now, financially and budgetarily, is barely squeaking by. And there have been numerous articles published about the condition of the school district financially. One question that I do think should also be answered is, I have had the opportunity to see some of the amounts that were generated from royalties associated with the well, and in the better times, not the worst times as far as oil prices were concerned, my understanding is the district received about $500,000 of royalties per year. So that would mean for an $8 million capping operation, assuming $500,000, which would have been a high, it would have taken the district 16 years to collect enough money to finance this abandonment operation. These types of extraordinary costs were not contemplated, and the deterioration associated with the well after it was abandoned and the state that the district found the well in when the district took over were far different than what was represented or what was anticipated, which is part of the reason why the costs were so high. The last thing that I think is at least helpful for the board to understand is the contractors would not actually step foot onto the site because of the liability situation. They required, because of the rising pressures and the design for the facilities, actually, let me take one step back. The facilities, and Mary Jane will know this better than I, the facilities were actually designed for a much lesser pressure. My understanding is the facility was designed for around 150 pounds of pressure. When the district took over the wells, they were in the 600 and 700 pounds per pound pressure. Mary Jane, in her foresight, was able to redesign and implement above ground facilities that were up to 1,100 pounds of pressure without having any knowledge of what was designed in the below ground portions of the facilities, which is why she's been monitoring the pressures. As we sit here today, my understanding is the pressures are coming close to 1,000 pounds of pressure because the pressures in some of the wells have been rising a pound a day. That is actually one of the reasons why many of the contractors were actually unwilling to step on site, and also it became exceedingly difficult to procure insurance. Of the insurance policies that were out there, there were approximately 6 to 8. Virtually all of them turned us down for insurance. So we were left with only 2 policies to negotiate with, and one of them actually pulled out, which left us 1, and that was Lloyd's of London. That was actually one of the reasons why it was so difficult to procure insurance. We had to procure it offshore outside of California. And when we finally were able to procure the insurance on April 19th, that was the first that we would be able to get the contractors actually on site. So much of the operation was literally stalled while we were in the process of negotiating contracts, procuring this very difficult to procure insurance policy.
Thank you, Mr. Tao. Ms. Byrd had questions. I don't know if you still do. Mr. Camarena? No. Anyone else? Senator?
The GAO bonds being floated for the sole purpose of this operation, or you mentioned GAO bonds, correct?
Yes, I'll kind of address the general obligation bonds. The school district actually had an active construction project that is going to far exceed the amount of available funds from a prior bond. So the district was planning on going out for a general obligation bond to finance the remainder of the construction project. If you drive by, you'll see that Beverly Hills High School is actually shuttered waiting for this construction project to commence. The general obligation bond primarily is to pay for the upgrade of facilities at the school district, with an aspect of which would be the procurement of funds for repayment of this obligation for the shuttering of the wells.
What's the total amount being requested in the bond measure?
It's three, I think it.
We don't know this is LaTanya Kirk Carter speaking. I can't remember the exact amount, but it's about close to 400,000. 400 million, I'm sorry, 400 million for the June 5th bond.
Okay. Right. During the operation of these wells, did the city per se derive any compensation like taxes or so much per barrel that went to the city of Beverly Hills?
This is LaTanya Kirk Carter. Yes, the city received equal royalty payments to the school district. So throughout the course of the lease, the city, whatever the district received, the city received an equal royalty payment.
And the city is in a better position at this time, what you testified to fund part of the project for capping the wells.
Yes, sir. They are definitely in a better position than the school district.
Well, driving down Rodeo in Beverly Hills, it looks like they can do it all. To be very honest with you. And I must tell you that these people here work on the weekends, 2 lawyers, staff, inspectors are here at the expense of this district. And if you don't compensate them for part of their services, then somebody else is paying for your services. And the other people who are paying for your services didn't derive any benefit at all from these wells. So it's a fairness doctrine as I see it. And yes, you can resolve this matter, but this district has to be reimbursed for the services rendered. You would do the same thing, make the same request in your operation as well. So maybe someone else can have their opinion, but that's mine. They're here, and it costs a lot of money. Beverly Hills and Beverly School District, top of the line, financially and otherwise. And to be laughed at if the people in the poor school districts would hear you saying we need to be granted relief from what our obligations really are.
Do you have any other questions, Senator?
I made my...
Well, anyone else have any questions for any of the school district witnesses? Seeing none. Oh, sorry, Dr. Lerner, did you have a question?
I would like to make a comment, if I may be permitted. No.
Comments, once we deliberate, I think it's the most appropriate time to make a comment. Mr. Sanchez, you had no other questions, I assume?
Nothing further, Chair.
And on this motion, you would have no witnesses, I assume?
No witnesses.
Okay. For Mr. Sanchez? Okay. I'm sorry, wait. Okay, let me first take Ms. Bird's question for one of the school district witnesses.
And I don't live in LA County, so when you make reference to the articles about the problems with the school district and their funding and that kind of thing, I'm really not familiar with that. And so I didn't get from you the reason, or if there was some specific reason that the school district was in this position and why they could not. I mean, I got the part of, and I don't know which one of you would answer that, I guess the administrator, how the school district is in this position.
LaTanya Kirk Carter speaking. The school district is not the city. So we are funded, we have, through a formula calculation, we have exceeded what we would get through state funds, and we're considered basic aid, so we get our money through property taxes only, but it is still the same, in the same realm as if we were a regular ADA school district, which would be the same as any other school district. For example, I was the superintendent of Inglewood Unified for 2 years, and Inglewood actually receives more money in categorical federal funds than Beverly Hills. Beverly Hills receives hardly any categorical monies. So being in the city, of course, though, the residents and the parents want an education comparable to the private schools. And the district, and they do fund that. The PTAs and our foundation are very generous to the district. The city is very generous to the district. But the actual educational product is, our competition is Harvard, Westlake, Archer, Oaks Christian, and the parents expect that from the district. All of our money goes into our education product. We are definitely not the highest paid our teachers are not the highest paid teachers. We have some of the lowest benefits in the county. All of our money goes into our education product. And so, unfortunately, though, you can't keep that going when your expenses are finite. And so it's really hard to make that decision. This year, we embarked upon closing down a school. And of course, the residents were up in arms. But we need to, in order to continue this high-level curriculum, I've been in education 30 years, and it is a higher bar that I'm accustomed to, but that is what is expected in this community. And so that is where what is straining our finances. The curriculum and the class sizes are lower, and it's the way that we're spread out.
I guess my question then is, you're saying that this is not a result of, the financial situation is not a result of any mismanagement on the part of the district. Like I said, I don't see the articles in the paper, so I'm not familiar with, no.
I'm sorry for cutting you off. LaTanya Kirk Carter, no, there has been no mismanagement of the district. Just to remain competitive, again, our teachers had the lowest salaries in LA County in 2014. They were in the lower quartile. And so the board, I mean, we just couldn't even hire teachers. And so they did embark upon trying to get the teacher salaries up and competitive, but nothing extraordinary. there's no extraordinary, no mismanagement, but there is an enhanced curriculum. It's not the curriculum, like when I was in Inglewood Unified as a superintendent, we didn't have a foreign language in our middle school curriculum. We didn't have visual and performing arts in our middle school curriculum. We didn't have some of the STEM classes as part of the curriculum. They may have been a club after school, but it is, our parents expect that there will be a foreign language taught at middle school, that they will have some access to visual and performing arts in middle school, in elementary school. And so that curriculum, that staff, those materials, they put additional costs on an already finite budget.
So you're saying that the bonds that you plan to release to raise this money, you could not include $45,000?
The general obligation bonds that Mr. Tao spoke of, those are construction bonds that we will be, that we're asking the public to vote for on June 5th. We have an existing GO bond. Those are for construction-related purposes. Unfortunately, this well is a general fund purpose because it's not a capital purchase. It's not a capital need. It's not a construction item, and it actually wasn't listed in our original bond. We have listed it in the new bond. So if the new bond is successful, we can use some of those funds if it's successful and being voted upon. We do have a very expensive bond. We have very old schools. Again, being in schools for 30 years, I'm used to schools that were built in the 50s and the 60s and the 70s, not schools that were built in the 20s. So our schools were built in the 20s, some of the oldest schools in Los Angeles. And so we have whole other construction constraints that I built a school in Hawthorne that wouldn't have because it was built in the 70s.
So if you did not receive the waiver today, what would the school district do?
We would take it out of our general fund. It's unfunded money. It's unbudgeted monies. As I told the chair, it's not like we don't have it. We have it, but it's money that we would otherwise use for educational purposes. It would come out of our reserves. We would restore that reserve when we close the books. But all of our money is budgeted for educational purposes.
And if you have an idea of what percentage of your general fund that $45,000 would be?
Less than, I'm sorry, LaTanya Carter speaking. Less than, way less than 1%. I mean, our budget is 70 million.
Okay, thank you.
Mr. Camarena.
I want to understand something you said. I thought you said that you need to be competitive with the private schools in the area. That means, that suggests to me that would be providing a higher level of education than in other areas of Los Angeles County.
LaTanya Carter speaking. It is enhanced, having worked in many school districts. Different school districts have different things that pull at their budget. The parents do expect us to be competitive or similar to the private schools in the area. However, when I was at Inglewood Unified, for example, we had our actual general funds were close to 70 million, but we also received almost 60 million in federal funds, which we used for enhanced education and enhanced curricular type items. But the districts themselves have different similarities, but they have different things that pull away at their budget. For example, Inglewood Unified has a full police force that we have to fund out of the district's funds. We have had constant vandalism, constant loss in textbooks. We may not have those types of problems at Beverly Hills, but we have different things that pull at our budget, such as repairing musical equipment, paying for consumables that go into that enhanced curriculum. So each school district is the same, different, but the same. So I would not say that the education was dramatically better, but the parents do expect, again, music inside as part of the child's school day. They expect a foreign language as part of the child's school day, whereas in maybe another school district, it would be a before school club or after school club that the children would have access to.
Before I take the senator's question with regard to Mr. Sanchez, or anyone else have any questions for the witnesses so that we can? Okay, Senator has a question.
Ms. Kirk Carter, you worked in Englewood School District, and you mentioned another school district, Torrance. Okay, then you are then aware, and then my question is, that the tax base of those districts compared to the tax base of Beverly Hills is far below. Is that correct? You worked in both, so you should know.
LaTanya Kirk Carter speaking. Yes, the tax base is much lower, higher in Beverly Hills. However, how school districts are funded, the foundation of our funding is not based upon your city's taxes. The city's revenue is based upon Beverly Hills taxes, but the school district's funding is based upon a formulized, a formula that was developed in '78, right after Prop 13, and it is a county-wide formula. So all of the counties go into setting the limit of where we are supposed to be. It's not just Beverly Hills for the school district, which is why we're not as well off as the city of Beverly Hills. The city of Beverly Hills actually receives that revenue from Rodeo and all that you see. The school district does not receive it like that. Our formula is much different than how the city receives their revenue.
Ms. Kirk Carter, I'm Nate Holden, the senator,
I know you.
and we have debated the compensation in Sacramento. I understand how the funding is appropriated. So I just want you to understand, and another question, that Beverly Hills gets its fair share. Now, may I ask a question when the time to Mr. Sanchez?
Let me just make sure, was there any other questions for the witnesses before we close the testimony? Yes, Dr. Lerner did.
Yeah, by way of background, I was in the medical office building and saw that derrick, or whatever you call it, that ugly thing on the grounds of Beverly Hills High School. I also have a lot of patients who are in Beverly Hills. I would like to ask you one question. You said that Beverly Hills, residents of Beverly Hills, want the school system to be as competitive with Harvard, Westlake, et cetera, et cetera, et cetera. Can you tell me the basis and fact of that, or is that just simply an opinion? Because I have heard quite the opposite. Doctors, other professional people, people who work for other companies want to move to Beverly Hills because they can get a very fine education without having to send the kids to private schools. They're not competing with the private schools. Beverly Hills school system is a magnet for certain people who want a higher educational system than they think they could get at LAUSD, and that's not an argument. I mean, that's just my opinion. This is what I've heard from people for the last 40 years that I've been in practice. So my question again is, what is the basis in fact? Where have you heard this? Is this a survey? It's published information so that I could understand that, your comment better about being competitive with Harvard Westlake. You're not competitive with Harvard Westlake. There's no question about that. Thank you.
LaTanya Carter speaking. I can't point to any survey. I'm not an educator. I'm the business manager. I actually live in Inglewood, so I don't live in Beverly Hills, and I'm not a resident. Our board, I've been associated with the district since 2009. I left in 2012 to answer the call from Tom Trollickson to go over to Inglewood Unified, and I came back in 2014. Our school board, our parents, when they speak before the board, the school board's desire, that's the commandment that they give to our superintendent and our educators when designing curriculum. When they're comparing test scores or comparing college entrance statistics, that's who they want, that's who they compare themselves to. So it may not, the benchmark that the board has set for the school district is the Harvard Westlake, the Oaks Christian, the Archer Marlboroughs, and things like that. But you are 100% correct. People rent, they pay way more than I would pay for a 2-bedroom apartment in Inglewood to live in Beverly Hills to have that Beverly School education. So they do move in the district for that education, and it is world renowned.
If I could, Terry Tao, on behalf of the school district. I represent a lot of school districts, probably about 500 in the state of California, which is roughly half. This school district is much like many of the other school districts that are high-performing that you're well aware of, such as the Diamond Bars, the Palos Verdes, the Laguna Beaches, and the like. They are a good school district, and they have much of the same budget problems as all of the other school districts in the state. After the passage of Proposition 13 in 1976, it became very difficult for school districts to function well. Like most school districts, this school district has to be very decisive and careful about what it is that they spend money on. When this district entered into the oil well arrangements in the 80s and had all these oil wells drilled, I'm sure that they never had the contemplation that the system would be so poorly maintained, abandoned, and leave the district at risk as they are. The district is now taking their responsibility and shutting down these wells, an expense that was never anticipated, because the original people who wrote the agreement way back did write in the agreement that there was a responsibility on the part of the oil well lessee, the operators who decided to put in these oil wells, to properly shut her down, to pay for all the expenses, and to ensure that the wells were properly closed for a safe environment. That did not occur. The district was left in a very awkward position, and before the district received it, much of the deterioration occurred. As you may have been able to tell, this is a little bit like one of those adventure shows where the situation is getting worse by the day. I've been living it. I never expected to become, I'm a construction attorney, a public works construction attorney. I never expected to learn everything about oil wells. And what I have seen is a deteriorating situation with a very serious safety component that the district is literally shelling money out for on a daily basis, and the city is also doing. So it's a very difficult position for the district, which is why we've asked for a waiver with regard to the fees.
Thank you. Any other questions before we close testimony? And
Can I make one comment that may address some of the senator's concerns? Mary Jane Wilson through the
You may,
chair.
yes.
And that is when we realized that we needed permit modifications with a fast turnaround. We have been paying expedited permitting fees in order to allow your staff to help with the situation. So we have been paying those. It was just the excess emissions fees we were asking for waiver because of the school.
Thank you, and I should point out, just for the record, that this board is an independent board, so the staff of the district is independent of this hearing board, just for the record. Thank you very much for that. You had a question for Mr. Sanchez, and why don't we go ahead and allow you to ask that question, and then we can have closing if we think that's necessary, and then deliberate.
Mr. Sanchez, how many attorneys I see two here right now been working on this project, this case?
Just me. I didn't know if I was going to be available today, so I asked Ms. Sue to monitor the situation in case she needed to appear.
You're the only one who's been working on this case.
Yes.
What about other staff people, engineers, inspectors, and so on that you know?
There's probably, well, in our meetings, there's been, probably 10 or so people, but there's Ms. Weibel, Maria Weibel is the primary engineer assigned to this facility.
So it's been about 10 people or so,
Yes,
including you.
yes.
It's quite an expense to the district, I would think. All right, thank you.
You're welcome.
Okay, seeing no other questions, and knowing that I have gone to Mr. Sanchez and there are no witnesses for the district, I don't know, either Ms. Carter or Ms. Wilson or Mr. Tao, if anyone would like to make a closing, or if you feel that we've adequately summarized your position. It's an emergency. Well, I could ask if there's any member of the public who wishes to be heard, but being as this is an emergency petition, I doubt that. Okay, seeing none. Is there a closing that you would like to make? You can waive closing as well, if you feel you've covered.
LaTanya Kirk Carter will waive closing. We think that we've given accurate testimony.
Thank you very much. And Mr. Sanchez, any closing?
Just to briefly give the board, because I'm sure there's a lot of questions. We didn't hear the matter this morning, but this is a very unique situation. The facility has approached the district early on to try to find out what was the best remedy and path forward to deal with the situation, maintain the safety, and proceed under the district's rules, regulations, and structure to achieve compliance and, close the site. Initially, as the testimony indicated today, the district was approached when the need for the flare was identified as the relief to reduce pressure at the facility. However, that would not, the facility could not seek a variance because that would require avoiding the permitting process. And so they sought expedited application of the flare application. We've been waiting for public notice to cease on that process. There still may be a need to bring on that flare before public notice expires. That would create an awkward situation to seek an order for abatement because thankfully no public nuisance has occurred because of the use of the carbon canister. Ultimately, the variance would have been relief from Section 203B of the of the district rules because they would have been violating the current permit condition. Again, another unique scenario because this facility is subject to Rule 1148.1, which is specific to oil and gas production facilities. However, because they have been shut in for over 6 months, they're allowed to vent. So the same reason why they're trying to be a good neighbor by venting through a carbon canister is also creating them a dilemma and a potential violation of their existing permit condition. The issuance of the permit today allows for emergency venting for the scenarios that have been presented to you today. So despite the relief that was initially sought, there do remain situations, exigent situations at the facility. The district and the facility will remain in touch. and there may be a need for additional relief as we go forward. So this record may need to be called upon in the future. We hope, and I believe none of us hope that that will be the case, but we are well aware and continue to monitor this situation going forward. Thank you.
Thank you. Mr. Camarena, you'd like to begin discussion?
The school district is faced with a significant safety issue, and it's costing them, I thought I heard, about $20,000 a day. I listened carefully to the budget problems. Also listened to the expectations of the public for their schools in that area. On the other hand, I sit on the Budget Advisory Committee for the district. And this year, the district is asking for some significant additional fees to cover new programs that have been required in order to continue its progress in cleaning the air, especially in these last, perhaps, decade where attention has been given to toxics. Another program is moving sources that have been in the reclaim program over to command and control. This is very expensive. And so these new fees, it does not appear that they may cover all of the additional cost. So we have on one hand the Beverly Hills Unified School District with its budgetary problems, and the Air District with its own budgetary problems. And for that reason, I cannot be sympathetic to the request.
It's a tough one. I am always very sympathetic to the state of our education. And having a child going through public schools currently, I am aware of many things that school districts don't have that I had when I was growing up, and it's concerning. So anytime I hear school districts struggling, it's difficult. I do want to put in perspective, though, unfortunately, we don't have before us the question of whether the $8 million needs to be spent, the $4 million that might ultimately fall to the school district, and all of the excessive amounts of money that will have to be paid. Hopefully, much of it will be covered by bonds, but I understand that that's not clear right now. But again, those things are separate from the request today, which is for $45,000. And I think Ms. Bird asked an excellent question as to what is the percentage of the budget of the school district, and the very candid, and I have to say that the witnesses were extremely candid and very credible, of Ms. Kirk Carter was less than 1%. And you have to weigh that against, Mr. Camarena, what you have to say about, the purpose of admission fees are not necessarily straight compensation for the use of or the time of staff, but rather the idea that these are some significant excess emissions, and that the hope is that the district will use those fees to then offset those emissions somewhere else. The better use would be in the immediate vicinity. I understand that's probably not going to happen, but that's quite important. And then balancing that and the fact that it's less than 1%, but understanding that there are mounting costs, and that you do want to look at the cumulative impact of all those costs to determine whether it is an unreasonable hardship, given everything else that this school district is facing financially. So I as of yet don't know where I stand. I'd love to hear other board members' thoughts. Ms. Bird seems to have some thoughts.
Well, from the testimony that I've heard, and it was very clear, and I appreciate that, I cannot, my position right now would not be to issue the waiver. And that is also based on my interpretation with the testimony of 303M, where we have the discretionary power to issue it, and it says, in its discretion, the hearing board can determine after hearing evidence thereon that payment of such fees would cause financial or other unreasonable hardship to the petitioner or is otherwise inequitable. I don't believe it's inequitable, and based on testimony, I didn't feel that it was an unreasonable financial or other hardship. I realize that there are other mounting costs, but those are the mounting costs. What we're being asked to issue a waiver for are these costs, not any of the other costs, even though they might be related to the whole. So based on testimony that I received, I would not agree with issuing a waiver.
Anyone else? Senator, do you have thoughts?
It's Kurt Carter. You're appointed to represent Inglewood School District by the superintendent, was that?
Latanya Kurt Carter, by State Superintendent Tom Trollixon.
Can we constrain to not opening back up
No, I'm
the?
not opening it. I'm gonna make a point.
Yes, please.
It's kind of
Thank you for answering, but we're close.
The fact of the matter is that there's no comparison between the poor districts and the rich districts, in my view. Beverly Hills District has derived funding from this process for a number of years, whereas Inglewood is in receivership. And some people don't even have books. And when things were going good, it was okay to have oil wells. Nobody complained about that. And so now they have to shut them down for a reason unknown to me. Maybe the city did it, protest from the community. I don't really know. But I do know this. Mr. Sanchez has stated that there are 10 other people from time to time been working on this project. It costs money to provide that kind of service. And if the school district is not going to reimburse a minimal amount, which the $45,000 is minimal compared to what the services that have been provided to the district over the years, they're not willing to do that. This district can't operate. That's why we're here. And if the school district is not paying for services rendered, other taxpayers will have to do it. And so that, for that reason, one, it's not fair. Two, Beverly Hills School District has done very well over the years and continues to do well. So I cannot, in good conscience, be on record, and you know what that means, be on record for voting to compensate Beverly Hills District.
Senator, I understand your points very well, and I think they're good overall. I just wanted to point out for the record that the admission fees themselves are not strictly stated compensation for use of district staff time. District staff is compensated separately. But I do want to draw attention back to the fact that these admission fees are not on. We've had many cases where there have been requests for waivers of fees. I think this is more on the inequitable line, but where the fees were, the emissions were far removed from any sensitive receptors or any people whatsoever, and they weren't of a harmful nature. And I think it's very important to bring back to the point that there was testimony that this was, just over the weekend, 23,000 pounds of VOCs, including benzene, toluene, xylene, which are toxic air contaminants, and that we also heard that's across the street from residences. And it's those impacts and those emissions that emission fees, at least in theory or theoretically, are sought to help to offset, at least district-wide, which it should be more of a more local nature, but That's important, I think, in weighing whether or not this is an unreasonable hardship. Any other thoughts? Would anyone like to make a motion? Ms. Byrd?
We're done with this discussion. Okay, in the matter of Beverly Hills, I'm sorry, I don't know the number. I don't have a number on mine. Case number 6107-1, the request for waiver of excess admission fees. I move that we deny that request.
Is there a second?
I'll second.
Any discussion on the motion? Seeing none. Senator, how do you vote? Dr. Lerner, how do you vote?
Aye.
I vote yes.
Yes.
And Mr. Camarena?
Yes.
So the motion passes 5-0, and the waiver request is denied. And any other business on this? Thank you very much, and thank you for your, as I said, for your excellent testimony and forthrightness. We do appreciate it at the board. Okay, board members, any other business for today? Seeing none, we are adjourned. Thank you all.